Good afternoon. Happy Saturday. This is a motion for Aaron Collins. For those of you who aren't aware, Aaron Collins is Great Lakes Audits, who was arrested on April 29th of 2022 in Toledo, Ohio. He is, I guess, coming up on trial here pretty quick. And anyway, he had the misfortune of falling in with our friend Chili De Castro, and Chili apparently hooked him up with Bobby Law, who is not an attorney, and Bobby Law apparently drafted this particular motion to dismiss for Aaron Collins. Now, I'm not going to speak to whether or not Aaron Collins is guilty or innocent. I don't know. I don't care. I'm going to speak to whether or not this is a good motion, a bad motion, and if it's bad, why is it bad? The first thing I want to point out is that in the summary of the case and procedural history, Bobby Law chooses to call Aaron Collins the defendant in error. Now that baffles me why he would do that. The only time I am aware of there being somebody called a defendant in error is if someone wins a lawsuit and there is a judgment, and the person who loses the lawsuit decides to file what's called a writ of error, a petition for writ of error, I should say. It's a petition for writ of error with the Court of Appeals saying that the judge who gave the jury instructions or whatever made an error in the application of the law. The judge got the law wrong. And so the plaintiff in error is the person who's saying the judge got the law wrong, the person who essentially lost the lawsuit. And the defendant in error would be the person who won the lawsuit. And that doesn't make sense. So I don't know why Bobby Law would choose to call Aaron Collins the defendant in error, because to the best of my knowledge, there has been no petition for writ of error filed. And this is a motion to dismiss, not a petition for writ of error. So there you go. I'm not going to go over the summary of the case and procedural history. It's going to state the facts. I'm assuming it's going to state the facts. I haven't gone through it in great detail, but I'm assuming it's going to state the facts that are most favorable to Aaron Collins. I'm going to generously say that Bobby Law is smart enough to state the facts that are beneficial to Aaron Collins. I'm just going to assume that arguendo. I did note, however, there was a listing of all the various charges that Aaron Collins is facing. You can see them here: obstructing, resisting arrest, failure to ID, disorderly conduct, aggravated menacing, and intimidation. Now, the Hamilton County Public Defender, who are in fact attorneys, and they are in fact in Ohio, they have basically a pool of motions that are common motions, and these are their motions to dismiss. And you'll see that they have a motion for disorderly conduct. Now, I have downloaded it, and you'll see that they cite all sorts of Ohio cases. See Cincinnati versus Carlin, citing Cohen versus California, which is a Supreme Court case, but they're actually referencing Cincinnati v. Carlin, an Ohio case. See State versus Hoffman, again, another Ohio case. So you can see that in a real motion to dismiss, it's going to reference cases that are actually from the jurisdiction that you're trying to get the motion dismissed from. So keep your eye out. Look for Ohio cases, Ohio Supreme Court cases, Ohio Court of Appeals cases. Look for Ohio cases during this. So we're going to start off with a memorandum. The memorandum goes by many names. It's not a mistake to call it a memorandum, but it can also go by things like memorandum of law or memorandum of points and authorities, and probably other names as well. In the memorandum, your goal is to take the facts that you've laid out above, uncontested facts, and apply the law to those facts. And again, remember, you're going to want to cite Ohio Court of Appeals cases and Ohio Supreme Court cases, if at all possible. Because and the reason why you're going to want to use those instead of Supreme Court cases, generally speaking, is because for a specific statute, say for example, disorderly conduct, the Ohio Court of Appeals and the Ohio Supreme Court are going to deal with appeals from the particular statutes that Ohio has and is enforcing. And in this case, it would be like their disorderly conduct would be Ohio Revised Code 2917.11 subsection A2. So they're going to have cases that are actually on point dealing with the specific criminal code and the elements of that criminal code, etc. So he starts off, Aaron Collins was video recording in public and recording public officials in the performance of their duties. It is persuasive, if not clearly established in a growing number of federal appellate circuit courts, that such activity is constitutionally protected. See Glick versus Knief, Turner v. Driver, and Smith versus City of Cumming. Now, one thing that I want to mention here, well, two things that I want to mention here is, first of all, we are in an Ohio state court. And these are all Court of Appeals decisions in the federal court system. And so they are, at best, persuasive. They're not precedent. They're not, the Ohio courts aren't bound to go along with what these particular federal courts have held. That's number one. Number two is that all three of these, Glick versus Kniff, Turner v. Driver, and Smith versus City of Cumming, they are civil cases. They're civil. We are dealing with a criminal case, so you're going to want to be looking at criminal cases from the Ohio Court of Appeals and the Ohio Supreme Court. Further, constitutionally protected activity cannot be converted into a crime. Miller versus United States, 230 F. 2nd, 486, 5th Circuit, 1956. So, wrong circuit. And again, this is going to be a Court of Appeals decision from a federal court, which is not binding on the Ohio courts. It's not precedent for the Ohio courts. Now, it says, the claim and exercise of a constitutional right cannot be converted into a crime. Now, if you look for this sentence in quotes, this part in quotes, you will not find it in Miller versus United States. It is not there. What they quoted is not there. This is the actual language that it uses. The claim and exercise of a constitutional right cannot thus be converted into a crime. Cannot thus be converted into a crime. So they're talking about a situation in Miller versus United States where there was a person who came to Miller's home, a Richard Morris came to Miller's home, and on Thursday. On Saturday, the police came. Or maybe it wasn't on Saturday. It was on Saturday when the police came, they started asking Miller if they could come in to serve the warrant on Morris. And Miller said no. And so they tried to charge Miller with a crime of harboring, aiding and abetting, things like that. And the federal court, and it was under a federal criminal statute. And the federal court said, look, you didn't have the right, the federal officers did not have the right to enter the house. And Miller was within his constitutional rights to require you to have a warrant to enter his house. And so, based on the facts above, the claim and exercise of a constitutional right cannot thus be converted into a crime. So it's not a general statement. Anytime you find these little picked things that, oh, this looks really good, they are always cherry picked, and they're dicta, because Miller versus United States wasn't dealing with turning a constitutional right into a crime. It was dealing with what the extent of obstructing, resisting, and opposing a deputy United States Marshal in violation of 18 U.S.C.A. 1501 is. That's what it was dealing with. So we're already 2 paragraphs into the memorandum, and we've not yet seen a single Ohio case. And then it says, defendant calling refers to the following. Rule 3 complaint. The complaint is a written statement of the essential facts constituting the offense charged. It shall also state the numerical designation of the applicable statute or ordinance. It shall be made upon oath before any person authorized by law to administer oaths. Great. It's a written statement of the essential facts constituting the offense charged is all underlined, and essential facts is bolded. Okay. And then subdivision A, apparently we're now looking at the obstructing official business. Officer Peters' complaint reads, defendant, while in the municipality of the city of Toledo at Beverly and Sherwood, did hinder postal worker Katie Keister, that's a real name, from delivering the mail by continuing to follow and harass her, impeding her route. This happened while this officer was present at the location. He goes on to say, this complaint fails to present any act committed by Collins whereby he impeded or otherwise obstructed Keister from performing her official duties. Officer Peter only renders the conclusion of harassment without presenting any necessary and essential facts that could facially support this charging instrument. Simply making a written rendering of this claim absent facts causes this complaint to be facially insufficient as a matter of law. Now it's moving on to B, resisting arrest. So that's all he has to say. He hasn't cited any case law that says that simply making a written rendering of this claim absent facts causes complaint. He's not citing anything for this proposition. Bobby Law is making a legal conclusion, and he's not citing on what grounds, on what case he's making this decision, on what interpretation, like legislative intent, that he's making this decision. So I assume, and the court's going to have to assume, that his issue is that it's not showing essential facts, and that he doesn't understand what essential facts are. So what a real attorney would do, and again, I'm not licensed to practice in Ohio, so I don't even know if this is a good case, but a real attorney would look to see what Rule 3 is really dealing with. And Rule 3 states, while all the specific facts relied upon to sustain the charge need not be recited, the elements of the crime must be stated. So the requirement is that you have to state the elements of the crime, not the specific facts, the elements of the crime. And you could read the rest of this to get it, because I know someone's going to be like, oh, well, it says, well, all the specific facts. So you have to state some of the specific facts. No, you have to state the elements of the crime. You basically have to say that person X did this element of the crime, this element of the crime, this element of the crime, and this element of the crime. And it doesn't have to like lay it out in that particular way. So theoretically, this could state all the elements of the crime. What Bobby Law should have done is he should have found citations for all of these assertions in here. And then he should have found, I don't know, a case that lays out all of the elements of obstructing official business. Ohio Revised Code 2921.31 subdivision A. That laid out all the elements to see if all of the elements were actually stated in Officer Peters' complaint for obstructing official business. But he didn't do that. He says in here, here's what the actual language of obstructing official business is, but it doesn't state the elements. a court would state the elements. So the second one is resisting arrest. Officer Peters' complaint reads, defendant, while in the municipality of the city of Toledo, did refuse to put his hands behind his back as instructed to do so by the officer several times. Defendant then had to be forcefully handcuffed. Apparently, handcuffed is misspelled, and so there's a SIC. SIC just means that that's verbatim how it was written in the complaint. So Officer Peters didn't spell check his complaint. One essential fact necessary for this charge to be brought is that a defendant must be placed under arrest antecedent to being charged with resisting arrest. And then this is where an attorney would cite to a specific case that says one essential fact necessary for this charge to be brought is the defendant must be placed under arrest. And you know, an attorney might also, just spitballing here, lay out the facts, the elements that are necessary to show that someone has been arrested. Because when is someone arrested? I'm sure that Ohio, much like California, is going to have case law on all the essential elements needed to be shown that need to exist, I should say, before someone is arrested, before the arrest has been made. So was the defendant resisting arrest? I don't know. Is an essential fact necessary for the charge that the defendant must be placed under arrest antecedent to being charged with resisting arrest? Maybe. We don't know. We don't know. And he's expecting the judge, I guess, to look it up. Now, the judge might go back and do the legal research. Might. The judge might have a clerk do the research. And by clerk, I mean actual attorney who works as a clerk for the judge, not one of the clerks who stamps documents with endorsed filed stamps, but an actual attorney. Or the judge just might simply wait for the response to this motion, the opposition to this motion, by the district attorney or ADA or whoever the heck does it in Ohio, and wait to see if they say whether or not this is correct or it isn't correct, and what cases they cite. He says Officer Peters is keenly aware that Collins had not been placed under arrest at the time he intended to handcuff Collins. What are the elements of arrest? What are the elements of arrest? I mean, it doesn't really matter if Officer Peters is aware of it or not. What matters is, was Collins arrested? Was he placed under arrest? Further, Peters had not detained Collins nor arrested him in accordance with the Ohio Revised Code. Which Ohio Revised Code? What elements are necessary? What Ohio case states what elements are necessary? The second complaint fails to present a claim by Officer Peters within the four corners of the complaint, presenting any necessary and essential facts that could facially support this charging instrument. Again, what elements of the crime did Officer Peters fail to state in his complaint? Simply making a written rendering of this claim absent essential facts causes this complaint to be facially insufficient as a matter of law. Citation needed. This is literally a case where a citation is needed. A lot of times, idiots arguing on the internet will say, oh, citation needed. Okay, and it may or may not be depending on the context, but in a memorandum of law, citations are absolutely needed. And I'm not going to go through any of the rest because you could see. Well, I'll just go through, I guess, really quickly. So failure to disclose personal information. There is no citation to anything, no citation to anything. Disorderly conduct. And down here, it just lays out the statutory language for disorderly conduct. This is the complaint. And again, there is no actual analysis of any case law that would suggest that somehow some element has not been stated. Aggravated menacing. This is, again, the elements of aggravated, not the elements, excuse me. This is, this first part, I guess, is continued from this page. And then this is the text of the Ohio Revised Code for aggravated menacing. So again, there's a complaint. Again, he just states that it fails to present any essential facts, not realizing that what it has to state are the elements of the crime. And then it's insufficient, blah, blah, blah. Intimidation of a witness. Again, we have the text of the Ohio Revised Code. The complaint, we have that it fails to present any factual elements, again, and yada, yada. So then a conclusion. Again, there is absolutely no discussion of any of the case law or anything like that. This footnote here is just a continuation of the footnote on the previous page. But again, completely devoid of any of the required arguments that should be made. So I would grade this particular motion as an F, because the only case law that it cites is not persuasive. It doesn't deal with Ohio. None of it deals with Ohio law. And 3 of the cases, where are we at? Here we go. 3 of the cases, Glick, Turner, and Smith, are civil cases. The 4th case, the citation to the 4th case is incorrect. And something I didn't notice is that it actually doesn't state where in the case the citation is from. So 486, it should be 486, 490. So the citation is incorrect. The cited text is also incorrect, thus cannot be converted into a crime. It's missing a word, which changes the meaning of it. So this is definitely an F. Thanks for watching. Bobby Law should not be practicing law, and have a great day.